Next point. Supposing that the builder is in bad faith. Pag builder is in bad faith, napakasimple. Simple lang. He loses everything. Okay? He becomes liable for damages. Wala. You build in good faith, you lose everything. The landowner can demand that you buy his land regardless of the value. Okay? No restriction na kailangan that it should not be considerably more. Wala yung mga ganong restriction. Basta in bad faith ka, o bilhin mo yung lupa ko. Okay? Kung ang building mo is worth 1 million, yung land na tinayuan mo is worth 5 million, pwede ka. You can be compelled to buy the land. Bad faith ka. Pasaway ka. Okay? Kasalanan mo. So, and you are liable for damages. The landowner would have the right to demand removal. Tanggalin mo yan. Lumayas ka sa lupa ko. Okay? Basta in bad faith. Wala. You have no rights whatsoever. Except, isa lang, yung recovery of necessary expenses for the preservation of the property. Why so? Kasi pagdating sa necessary expenses, since these are supposedly incurred for the preservation of the property, the landowner himself would have incurred the same expenses, even if he was the one in possession of the property. So, in terms of fairness and basic justice, the law mandates that the builder in bad faith should be entitled to this. Okay. By the way, sabi natin, everything produced, all fruits of the property belong to the owner. Okay. Siguraduhin lang natin na talagang fruits. Okay? There is an old case, yung bonus. Certain landowners were asked by a certain company, pwede ba, sabi nila, i-mortgage ninyo yung mga lupa ninyo para makasecure kami ng loan. For the risk you are going to take, we will give you certain bonuses. O pumayag, may mortgage. So, binigyan ng bonuses. Are these bonuses fruits? The answer is no. Because they were not produced by the land. Okay? Hindi yan fruits. Okay? They're not even civil fruits. All right. Bigla ko lang naisip, baka maitanong. Okay. Next point. Supposing that both the landowner and the builder are in bad faith. Madali yan. They are both considered to have acted in good faith. So, you apply the provisions of Article 448. Supposing that the builder used the materials of a third person in building on the land of another. Okay? A lot will depend on whether the builder and the landowner are in good faith or in bad faith. Assuming that they are both in good faith, both the builder and the landowner are in good faith, and the material owner is also in good faith, ano magiging rights ng owner ng materials? The owner of the materials, of course, can recover the value of his materials from the builder who used it, but the landowner can be held subsidiarily liable for the value of the materials in case the builder is unable to pay the owner of the materials their value. If, however, the builder is in bad faith and consequently the landowner demands the removal or the demolition of the building, remember that the landowner would have no subsidiary liability. Okay. Ano reason? In accession, he who benefits from the accession must pay for it. That's one underlying principle. Kung sinong nakinabang sa accession, dapat magbayad. That's the reason why if the landowner decides to appropriate the building, there is subsidiary liability on his part in case the builder is insolvent. If the landowner, however, decides to ask for the removal, destruction of the building, he does not benefit from that accession, and therefore, that's the reason why there will be no subsidiary liability on the part of the landowner. Okay. Which is also the reason why if the property is sold, by the landowner pending payment of the indemnity to the builder. Okay. Ang tanong is, who will pay the indemnity to the builder? It depends. If in the contract of sale between the landowner and the third person, the landowner was already paid not just the value of the land, but the value of the building as well, then obviously the landowner must pay the value of the building, the proper indemnity to the builder. If on the other hand, the landowner was not paid the value of the building, then he does not benefit from the building. It would then be the buyer who will benefit from the accession. It would be the buyer who will have to pay the builder the proper indemnity. I repeat, he who benefits from an accession must be the one to pay for it. Okay? All right. Let's now go to the matter of alluvion. We have the provisions of Article 457. If you are the owner of a parcel of land adjoining the bank of a river, and due to the natural action of the water, over a period of time, deposits of river silt are left there by the water, such that the area of your land gradually increased year after year. You are the owner of that additional area. Your ownership is automatic. The additional area brought about by alluvion automatically belongs to the landowner of that land adjoining the banks of a river. It is not, however, I'm referring to the additional area. It is not, however, automatically registered or covered or protected by the torrents title of the landowner. He has to register it in his name. And if prior to his registration of that additional area, a third person succeeds in occupying that area, claiming it as his own, satisfies the requisite for acquisitive prescription, tapos. That third person would have acquired ownership of that area. Okay? So, I repeat, if you're the owner of property adjoining the banks of a river, in the course of many years, due to the gradual deposit of river silt, lumaki na lumaki yung area mo, automatically, As long as everything happens naturally. Hindi ka nag-construct ng catchment basin or whatever there. No human intervention. You are automatically the owner of the additional area through alluvion. But that additional area is not automatically covered by your torrents title. Kung may torrents title ka doon sa property mo, your torrents title will not automatically extend to the additional area. Therefore, the additional area can still be acquired by third persons through acquisitive prescription. The increase in the area must be exclusively due to nature. There must be absolutely no human intervention. Otherwise, that's not alluvion. Insofar as areas bordering lakes are concerned, like Laguna de Bay. Laguna de Bay is not a bay. It is a lake. Okay. Lakes are large bodies of water which usually have a connection with the river. Yan ang lake. What about the areas there? If there are additional areas brought about by the action of the water or whatever, to whom would these additional areas belong? They would belong to the owners of the adjacent lands, applying the Spanish law of waters. If you own a parcel of land, let's say in La Union, and through the action of the sea, your land gradually increased in area. Nasa may tabing dagat. Who would own the additional area? Kabalikat sa kaunlaran. Huwag natin pakialaman yan. That belongs to the state. Itong alluvion, applicable lang sa rivers. Okay? Hindi kasama dito mga shores of the seas. Pero, applying the Spanish law of waters, if what is involved is a lake, like Laguna de Bay, or Lake Lanao for that matter, the additional area will also belong to the owner of the adjacent land. Kung sino may-ari ng property. Okay? Alright. Next point. O gutom na ba tayo? Ha? O kain na muna tayo? Sige. So, we meet at 2 o'clock, ano? Okay.